How do you resolve share valuation disputes in shareholder agreements? Imagine a business where shareholders can't agree on what the company is worth. Disputes like this can slow down or even stop a deal. So how do you fix this? Well, it starts with what is written in the shareholder agreement. A good agreement clearly states how shares are valued when someone wants to buy, sell, or exit. It might use a set formula, like a fixed percentage of earnings, or look at the company's book value or market value. Sometimes it includes discounts for lack of control or marketability. Without these clear rules, disagreements can become complicated and hard to settle. When a dispute pops up, the first step is usually negotiation. The shareholders talk directly to try and reach an agreement. If that doesn't work, they might bring in a neutral mediator. A mediator helps both sides communicate better and find common ground without going to court. This process is faster and less costly. If they still can't agree, the next step is often hiring independent valuation experts. These experts look at the company's financials and use methods like discounted cash flow or comparing similar companies to give an unbiased share value. Their reports are important because courts or arbitrators will consider them when making a decision. Many shareholder agreements include arbitration clauses. Arbitration is a process where an arbitrator, who is an expert in business valuation, hears both sides and makes a binding decision. This method is usually quicker, more private, and less expensive than going to court. But if arbitration fails or is not included, the dispute might go to court. Court cases can take a lot of time and money. The judge will look at the agreement, the company's financials, and other factors like market conditions to decide what the shares are worth. Courts have broad discretion and will try to be fair, but the process can be lengthy and may strain business relationships. To prevent these disputes, companies should have clear rules in their shareholder agreements. They should specify how shares are valued and include dispute resolution steps. It helps to have buy-sell provisions that lay out how shares can be transferred and valued. Planning for deadlocks or minority shareholder issues upfront can also save trouble later. Engaging experienced lawyers when drafting these agreements ensures all valuation and dispute resolution methods are clear. In the end, resolving share valuation disputes involves following the rules set out in the shareholder agreement, trying negotiation and mediation first, involving valuation experts, and resorting to arbitration or court only if needed. Having clear, detailed provisions in the agreement is key to managing and settling these disagreements smoothly.